Hello, everyone. Today we're going to be talking about civil rights, and really when we talk about civil rights is we're talking about equality for everyone. Usually when we say equality for everyone, we think about African Americans, but there's multiple people that we're talking about equality for everyone. For starters, this is review, but we're going to quickly go over Plessy versus Ferguson. This was a Supreme Court case that said separate but equal. And what that meant is whites and blacks went to segregated facilities. That could be schools, that could be water fountains. It just meant white and colored people. If you weren't white, you had to use different things. And it was supposed to be separate but equal, but things were not equal. You can see the white water fountain, very nice. The water fountain for colored people is not nice. And this is a school for African Americans right here, and you can see there's not much there. It's not a very good school. So what we're going to talk about today is a Supreme Court case called Brown versus Board of Education. And this is important because the Supreme Court decision in 1954 that said segregated schools are unequal and must desegregate. So that just meant schools can no longer be separate. You can't have schools for black people, you can't have schools for Hispanic people, you can't have schools for white people. Schools have to have both black and white students. And the case reversed Plessy versus Ferguson. So remember, Plessy versus Ferguson said people had to be separate. But now, Brown versus Board of Education and got rid of it and said, nope, people are all going to go to the same school. Another case that was important was in Virginia. It was called Davis versus County School Board of Prince Edward. And it was the same thing. They said that schools had to be desegregated. Some important people in the Brown versus Board of Education court case are Barbara Johns. She was a student leader in Prince Edward County. So she was a black student who did not want to have separate schools, so she tried going to an all-white school, even though she was African American. And Thurgood Marshall, he was the NAACP legal defense team, so he was a lawyer for the NAACP. And the NAACP we're going to learn more about later, but it's an organization that helps African Americans. Oliver Hill was NAACP legal defense team in Virginia, so he was a lawyer for the NAACP in Virginia. And Earl Warren was the Supreme Court Chief Justice. He's the one who said schools can no longer be separate. Everybody has to go to the same schools. Next, we're going to learn about Virginia's response to Brown versus Board of Education. A lot of white people in Virginia did not like that schools had to be desegregated. They liked it when schools were all white people or all African American. They didn't like that it was going to mix. So there was massive resistance, and resistance means they didn't like it. They closed several schools. There was also the establishment of private academies. So a lot of white people paid for their kids to go to schools with no black kids. They didn't want their kids going to public schools, let's say like Jeb Stuart High School, so they paid money. They went to schools that are all white. And there's something called white flight. And what this is white flight from urban school systems to suburbs. And what that means is white people moved away from cities to places where few black people lived. This one right here, it's a chart. It shows you the city of Baltimore, which is Maryland. But in 1790, you can see there was a lot of white people, and there wasn't that many African Americans. But in the 1950s, when schools become desegregated, there starts to be a higher percentage of African Americans, and a lot of white people start leaving the city of Baltimore. They start going to suburbs. And a large part of it is they didn't want to go to schools that had African Americans inside of it. So they call that white flight because white people were leaving the cities. The NAACP is the National Association for the Advancement of Colored People. You usually just going to hear NAACP though, and it challenged segregation in courts. Remember, segregation is where people are separate. They don't like that. They challenge segregation. And the association had a long history of working to overturn the Plessy versus Ferguson decision. So they didn't like the separate but equal decision that was from Plessy versus Ferguson. In 1963, there was a march on Washington, and participants were inspired by the I Have a Dream speech given by Dr. Martin Luther King Jr. In his I Have a Dream speech, Dr. Martin Luther King Jr. talked about how everyone should be equal. This is a picture. This is actually in D.C. That's the Washington Monument. And you can see there was lots and lots of people there. They wanted to hear Dr. Martin Luther King speak. He was very big on people being equal. And that's why we have a holiday to celebrate him. And the march helped influence public opinion to support civil rights legislation. So a lot of people started believing everyone should be equal. And the march demonstrated the power of nonviolent mass protests. So you can make change without being violent. You don't have to go burning down cars and destroying buildings. But if a lot of people get together and protest, you can make change. And we see that in D.C. now. There's lots of people that protest. We're going to talk about the Civil Rights Act of 1964. And this is a law that prohibited discrimination based on race, color, religion, gender, or national origin. So you can't treat people different because of their race, religion, color, or country. So if they're Hispanic, if they're African American, if they're Asian, you can't treat them differently. You can't say, oh, I'm not going to hire you. You can't work here because you're Asian. Like, that would be illegal. You also can't discriminate based on religion. So if somebody's a different religion, you can't treat them differently. Same thing with color or country of origin. If somebody says they're from El Salvador, you can't say, well, I don't want to give people a job from El Salvador. Or if me as a teacher, I said, oh, you're from Honduras, I'm going to give you an A. If you're from Bolivia, I'm going to give you an F. That wouldn't be legal. It also desegregated public accommodations. Desegregation means it's no longer separate. So hotels, restaurants, movie theaters, those places used to have black rooms for black people, white rooms for white people. In restaurants, white people had to sit in one area, blacks sat in another, but that got rid of that. So now people can all sit together. And President Lyndon B. Johnson played an important role in the passage of the act. So President Johnson wanted this. Next, we're going to talk about the Voting Rights Act of 1965. And this outlawed literacy test. So you can't make people test to vote. Early in the year, you guys took a test. I remember giving it to you. It was very difficult. If you failed the test, you weren't allowed to vote. But this made that illegal. You can't force people to take a test to vote. And federal registers were sent to the South to register voters. And what this Voting Rights Act did is it resulted in an increase in African American voters. It was very hard for African Americans to vote before this law. But after the law, it made it easier. And once again, President Lyndon B. Johnson played an important role in the passage of this act. So Lyndon B. Johnson helped out with both the Civil Rights Act and the Voting Rights Act. The next act we're going to talk about is the American Disabilities Act, also called the Section 4 of the Rehabilitation Act of 1973. And this prohibited discrimination on the basis of disability in federal programs and by receipts of federal financial assistance. So if somebody has a disability, you can't treat them differently. If someone has a wheelchair or someone has to walk with canes, or if someone can't see that well, you can't treat them differently. You can't not give them jobs. You can't not help them because of that. And another act is the Individuals with Disabilities Education Act. And this required that all children with disabilities receive a free, appropriate public education. It's kind of similar to the other one, just this one has to do education. So it doesn't matter what your disability is, you are entitled to a free education just like everybody else in the United States. The Supreme Court and the membership of the United States Supreme Court during the end of the 20th century and earliest 21st century has included women and minorities such as Sandra Day O'Connor, Ruth Bader Ginsburg, Clarence Thomas, Sonia Sotomayor, and Elena Kagan. And what the Supreme Court does is it protects the individual rights enumerated in the Constitution of the United States. So Congress makes laws, the president enforces laws, but the Supreme Court makes sure they're constitutional. If the Constitution says it can't be done, then they'll say that law isn't legal. This still comes up recently. I don't know if you guys remember in the news, but President Trump tried to ban people from particular countries like Syria, Iraq, Somalia. But the Supreme Court said you're not allowed to ban people from countries. So the Supreme Court does protect people. It doesn't matter. They can override the president. They can also override current laws. Next, we're going to talk about the right to privacy. And the Supreme Court identifies a constitutional basis for a right to privacy that is protected from government interference. So the Bill of Rights says you have the right to privacy. And we're going to talk about two court cases. First one is Roe versus Wade. And this established the precedent of right to privacy. It's also known because it made abortion legal and said people have privacy with their doctor. So when you go see your doctor, the doctor can't tell people why you went there. And it used to be if you were pregnant, you were not allowed to get an abortion. But now in the United States, if you're pregnant, you are able to get an abortion. And that's Roe versus Wade. Riley versus California. This protects the privacy of digital information on cell phones. So what this means is police can't search your phone without a search warrant. If a police officer walks up to you and says, "Can I see your cell phone?" You have to say, or you can say no. You don't have to give a police officer your cell phone unless they have a search warrant. If that's the case, then yes, you do have to give them your cell phone. In the civil rights movements in the 1940s, 50s, and 60s provided a model that other minority groups have used to extend civil rights and promote equal justice. There's two more cases we're going to talk about, then we're done. The first one is Loving versus Virginia. And this protected equal rights for individuals, struck down state laws that prohibited interracial marriage and held marriage was a fundamental right. All this means is people of different color were allowed to get married. There were some states, if there was a black person and a white person, or a Hispanic person and a black person, or another white person, if they tried to get married, they would say no. Some places, if you're white, you had to marry a white person. If you're black, you had to marry a black person. But Loving versus Virginia, that said, doesn't matter what color people are, you're allowed to get married. And Arizona versus the Intertribal Council of Arizona invalidated a state law requiring proof of citizenship during the voter registration application process. A lot of tribal, that's like Native Americans, they had trouble registering to vote because they didn't always have proof of citizenship. But that law says you don't need proof of citizenship when you're registered to vote. When you go vote, you do have to show proof of citizenship, but for that one, you did it. All right, the last two, we're going to talk about the rule of law. And this is where all persons, institutions, and entities are accountable for the law. So we're going to talk Gideon versus Wainwright. And this requires states to provide counsel for needy defendants charged with serious offenses. So if you're charged with the crime, you get a lawyer for free. You do not have to pay for a lawyer. The government has to give you a lawyer, which is good because it helps people. Sometimes people aren't guilty and they have to prove it. Next is Snyder versus Phelps. And this upholds that protests of public concern are entitled to greater protection under the free speech clause of the First Amendment. And what this was is Phelps has a church in Kansas. It's a person, and he protests funerals. So people are allowed to protest at funerals. All right, if you guys have any questions, let me know. There's a Wiser Me you're going to be completing, and we're going to move on to the next unit, next class. Let me know if you have questions.